A Ninth Circuit unpublished case just came down, Anheuser-Busch, which says that you can enforce an agreement with an employee to post-employment certify that they did not take or use your trade secret and confidential information. In that case, Anheuser-Busch sued a former employee who left, and after he left, he called up one of his buddies and said, "Hey, send me the recipes." And the guy did without getting approval. And then they sued him. He turned them over to some plaintiff lawyers who were bringing a class action, and they sued him to enforce their contract and for trade secret theft. And they said he brought an anti-SLAPP claim to make things more complicated. The court said, well, yes, because of the allegations about the other case, and it's an anti-SLAPP issue. But then they also, the second time around, they shot down the anti-SLAPP by saying that Anheuser-Busch had a likelihood of success because he breached his certification agreement, even though it was for a post-employment obligation, and also because of his misdeeds with nefariously getting information from one of his former employees that they were all aware was trade secret or confidential. And so that non-published appellate opinion just came down, and Anheuser-Busch should be pretty happy.
Okay, so we will sort of breeze through some of the discrimination things. Just wanted to start with the Fair Pay Act in California. It was put in here in 2015, and it is one of the strictest in the United States. The standard is actually if you have two people of the opposite sex performing substantially similar work, it used to be equal work, now it's substantially similar work, then they need to receive the same compensation. There are bona fide qualifications there, their years of experience, their education, and other things that they might bring to the table. So it isn't absolute, but I do get the question a lot, is a fourth-year attorney a fourth-year attorney a fourth-year attorney? I mean, is it all the same? And you may need to sort of, other than the years of practice, qualify what they're working on if you do want to have significant distinctions. Bonuses can also be used to reward certain, contributions as instead of having very disparate salary levels. And then, so the whole thing about fair pay is that the idea was we're going to open up, there's going to be disclosure. And so the second piece of this says employees can't be retaliated against if they're asking about pay. And a lot of the laws that we're seeing, like with the provision that says now that you can't require someone to provide their prior salary. The idea is that, they can ask about it, but we're not going to take someone's prior salary and use that to keep them at a lower level. So if you have a man that you're hiring and he says, well, I make 100,000, you offer him 120, and you have a woman who's making 80, and then you offer her 100, and you say, well, I'm offering both people $20,000 more, but in fact, the prior discrimination, if you will, the prior lower salary will carry forward. Then it was expanded. So in 2017, equal pay goes also to race and ethnicity. I'll sort of hurry through some of this, but we're also happy to stay after and answer questions. We can't look at the prior salary alone to justify compensation disparities. And then now we can't even ask about the prior salary, and employers actually have to disclose pay scales. I was waiting, you probably were too, for the regs that would actually tell us what pay scale meant, and it didn't really help. It just sort of said that you have to give the range. Tons of questions about disabilities. Any of these slides we could probably spend an hour on. The new buzzwords, or not that new, but the buzzword would be that we have to enter into the good faith interactive process. So if you have an employee that comes forward and says, hey, I have a disability, I'm unable to do my job without X, then you just have to show that you've done a dialogue. I mean, a lot of times I have employers who call me and they say, hey, what about this? And I say, well, what did they say? Well, I haven't talked to them yet. Yeah, should I talk to them? Can I talk to them? Of course, yeah, talk to them. What do they need? And maybe it's not that complicated.
And just a super important tip on interactive process, email, document it, document. I had a case where we won summary judgment. It was a disability discrimination case. We won summary judgment on everything except the interactive process claim. California says the interactive process claim is a standalone claim that can be tried by a jury. We won the jury trial, but it cost a few more bucks to defend that.
Sure. And, where I've had some issues is with respect to people asking for extra leave after their leave time is over. And people think, oh, you get 12 weeks of family leave or disability leave, and then it's run out, so we're gonna let you go. And if the person comes in and says, hey, I need another 4 weeks, you really better give that other 4 weeks, because that itself has been found to be a reasonable accommodation.
An unpaid additional leave.
Right. Although not indefinite. But what is indefinite? It's more than 3 months. So,
how much information do they have to give you in order for you to continue to grant their leave versus terminating them for failure to provide information about why they need the leave? We've had a situation, oh, I need a medical leave, but without giving any information because it was personal.
well, they need to provide a doctor's certification. They don't need to tell you or give you the medical details, but the doctor needs to say that they need to be out and are disabled through a certain date.
Right. It doesn't have to be a doctor either. In California,
true.
we recognize medical professionals, which include masseuses and acupuncturists and all kinds of other fringe types of persons. And so, and also you don't want to ask them about what their condition or medical condition is. You can ask them, what do you think a reasonable accommodation is? Or what do you think you need? Actually, I like to say, what do you think you need for an accommodation? And if they say, well, I need a sun deck built for me, and I need to work from, 3 to 5 only, then I can take that into my consideration as to whether that's actually a reasonable accommodation or that's an undue burden on my business.
For sure.
And this might be a brain dead question, but I assume the size of your business, right, plays into these kinds of things, right?
Yes.
If you're a 3-person office, it's not the same expectation of that 4 more and 4 more and 4 more weeks of leave than if you're like a 25-person establishment.
Yes.
You're saying yes, and he's giving me
You're
this
saying
look.
no.
You just
Okay.
I mean, let me put it this way, a small business needs to consider whether they can have a temp doing that job for the unpaid leave that this person's asking for, or somebody else do that job. I mean, you can't just, I don't think there's any black line that says, 4 more weeks is an undue burden.
Oh, yes, no, I was just saying in terms of generally, as far as accommodations go, the size of the business would factor in as to what is reasonable.
Yes.
But I agree, on a 4 more weeks, I would never, it would be a rare case that I would say someone couldn't have 4 more weeks. It's hard because the way these come in is not, I'm gonna need, it comes in little pieces and you get really tired, I know, of granting them, but you sort of need to for a while.
But if you have a medical provider who says they'll be coming back full-time, no restrictions in 4 weeks, and that medical provider does that on multiple occasions seriatim, then it's my opinion that medical provider is not reliable. And at some point, it's reasonable for HR or for the business to decide that this is an indefinite leave, which is, sorry.